Welcome to this explainer. Today, we're unpacking a really fascinating, high-stakes courtroom drama. Think about it. What actually happens when the aggressive tactics we absolutely need to catch organized criminals collide head-on with your basic human rights? It's a massive battle, and it goes right to the heart of how justice actually works in practice.
Okay, let's dive into this. Just imagine waking up one morning to find your bank accounts frozen, your business completely shuttered, or your property seized by the state. And the wildest part? You never even got a warning, no chance to defend yourself in court beforehand, nothing. So can the government actually do that? Well, in South Africa, the answer lies in a really powerful piece of legislation called the Prevention of Organized Crime Act. And honestly, it sets the stage for our entire discussion today.
The Constitutional Court of South Africa stated it pretty plainly here. Conventional criminal laws just weren't cutting it anymore. You see, syndicate bosses and gang leaders, they are notoriously good at insulating themselves from the actual dirty work. If you're only punishing the foot soldiers but letting the big bosses keep their mansions and secret bank accounts, well, the crime just doesn't stop. So this law was built to literally strip criminals of the proceeds of their crimes. It removes that financial incentive entirely, even if there isn't a traditional criminal conviction.
To understand exactly how this plays out, here's our roadmap for today. First, we'll look at the organized crime threat. Second, seizing property without warning. Third, the constitutional conflict that arose. Fourth, the rule nisi solution. And finally, balancing justice and rights. Let's get into it.
Starting off with Section 1, the organized crime threat.
So the backdrop here is absolutely crucial. For a young democracy facing severe threats from things like money laundering, gang activities, and racketeering, the state had to hit the syndicates where it hurts the most, right? Their wallets. And they had to act fast. Under the Act, once the state gets a preservation order to freeze someone's property, they have exactly 90 days, no more, to apply for full forfeiture. This isn't some slow, drawn-out bureaucratic process. It is a rapid, aggressive strike specifically designed to lock down illicit wealth before it can be moved offshore, hidden, or just completely destroyed.
Moving right along to Section 2, seizing property without warning. Now, what's really interesting about this is the tool the state uses to freeze these assets. It relies on a very specific legal concept, ex parte. It basically means a one-sided legal request. The state goes to a judge and asks to freeze your property, but they deliberately do not tell you they're doing it. You aren't in the room to defend yourself. Now, why on earth would they do that? Well, because the government desperately needs this element of surprise. Think about it. If they give a mob boss advance notice that they're coming for his assets, those assets are going to be wired out of the country before the court hearing even starts.
But hold on. The state can't just freeze things completely arbitrarily. The law dictates a specific threshold. The court must make the order if there are reasonable grounds to believe the property is either an instrumentality of an offense, like, say, a warehouse used to store contraband, or the proceeds of unlawful activities, like a luxury car bought with laundered money. It's admittedly a pretty low threshold, designed so they can act fast, but it absolutely requires at least a reasonable suspicion grounded in actual evidence.
Which brings us to Section 3, the constitutional conflict.
All right, so this puts us on a massive collision course. The dramatic turning point in our explainer happens when the Johannesburg High Court stepped in, reviewed Section 38, and just dropped a bombshell. They declared the law unconstitutional. To understand why, they looked at a sacred maxim of justice, audi alteram partem. It basically translates to listen to the other side. You see, Section 34 of the South African Constitution guarantees everyone the right to a fair public hearing before a court makes an order against them. The High Court looked at these ex parte surprise attacks and basically said, look, this completely destroys the right to a fair hearing. You simply can't just take someone's property without letting them speak.
So we have a profound clash here. On one end, the High Court ruled that Section 38 was invalid because it forced these one-sided applications and completely stripped away the right to be heard. But, as you might guess, the case didn't stop there. It went all the way up to the highest court in the land, the Constitutional Court. Taking a slightly different view, the Constitutional Court recognized the citizens' right to fairness, sure, but they also objectively validated the government's desperate need to fight crime. They actually ruled the law was valid, mainly because the text didn't explicitly forbid courts from adding their own temporary safeguards to protect people. Kind of an interesting loophole, right?
Let's dive into how they actually fix this in Section 4, the rule nisi solution. To save the law while still protecting citizens, the Constitutional Court used a really clever procedural hack called a rule nisi. Think of it kind of like a game of chess where one player gets to temporarily pause the timer. The court issues a temporary freeze on the property right away, so they secure the board and make sure the assets can't be hidden. But, and this is absolutely crucial, it is not final. It comes with a built-in return date, officially calling the affected person to court to give them their fair turn to speak and argue why the freeze shouldn't become permanent.
But wait a second. Section 38 of the Act didn't actually mention a rule nisi anywhere in its text, so how could the Constitutional Court just add it in? Well, they pointed straight to Section 173 of the Constitution. This basically asserts that courts are not completely powerless when a statute is silent. High courts actually have the inherent power to protect and regulate their own process. They can adapt old common law practices to solve modern problems. Essentially, they can bridge the gap themselves to ensure the whole process remains fair.
Let's move to the next part and see how this builds step by step in a real courtroom scenario. Step 1, the state launches its ex parte surprise attack. Step 2, the judge grants a temporary rule nisi freeze immediately, locking down and protecting the assets. Step 3, the property owner is finally notified and gets their return day in court, meaning they get their fair hearing to defend themselves. And finally, Step 4, only then does the court actually make a final decision on forfeiture. It's honestly a perfectly choreographed dance between state power and individual rights.
Which brings us nicely to our final part, Section 5, Balancing Justice and Rights.
Ultimately, the Constitutional Court created this incredibly elegant compromise to balance these massive, competing priorities without breaking the constitutional framework. If you look at it, to fight organized crime and prevent the dissipation of illicit assets, the state gets to use its ex parte surprise applications. But on the flip side, to protect human rights, the court deploys the rule nisi. Plus, the law even allows individuals to claim reasonable living and legal expenses from those frozen assets in the interim. That way, they aren't just starved out while waiting for their trial. So this temporary deprivation of property is legally justified simply because it's so narrowly tailored to protect society while still giving the individual their actual day in court.
So the crucial point is, well, there are a few main takeaways here. First, when reading the law, courts must try to interpret it in a way that preserves the Constitution, if at all reasonably possible. Second, the fundamental right to be heard is so sacred that it's never just assumed to be excluded unless the law explicitly and clearly demands it. Also, courts possess flexible, inherent powers to bridge any procedural gaps they find in the legislation. And finally, briefly limiting someone's rights, like through a temporary asset freeze, is totally justified if it's really the only effective way to dismantle powerful criminal syndicates.
We've seen how the Constitutional Court navigated this crazy tightrope using the rule nisi. But, as crime evolves and technology makes hiding illicit assets even easier, this tension is only going to grow. And it leaves us with a truly profound question to ponder. Where exactly do we draw the line between the urgent, desperate need for society's security and the sacred right to individual liberty? Something to think about. Thank you so much for joining me on this explainer. Keep questioning, keep learning, and I'll catch you next time.